Hello learners, I am Dr. Naveen Tiwari, Associate Professor, School of Computing, Graphic Era, Hill University, Bhimtal Campus. In the last lecture, we were discussing about cybersecurity frameworks and standards. In this lecture, we will see legal and regulatory compliance in cybersecurity. Our learning objective in this lecture are understand legal aspect of cybersecurity, understand regulatory bodies of and compliance in cybersecurity. Introduction to cybersecurity compliance. Cybersecurity compliance refers to the adherence to law, regulations, standards, and policies designed to protect digital systems, networks, and data from cyber threats. It ensures that organizations implement appropriate security controls and practices to safeguard sensitive information. Importance of cybersecurity compliance. Legal obligations, customer trust, reputation management, data protection, avoidance of penalties, and business continuity. Importance in financial inclusion. Now, data protection. It ensures sensitive data security. Fraud prevention. It reduces the risk of scams. Customer trust. It boosts confidence in services. Financial inclusion encourages safe participation of people in financial management. Now, types of cyber threats. There are many types of cyber threats. Some of these are malware, ransomware, phishing, and insider threats. Key cybersecurity principles: authentication, risk management, confidentiality, etc. Overview of legal frameworks. Information Technology Act 2000. Its primary legal framework for electronic commerce and cybercrime in India. Key sections relevant to cybersecurity are sections 43 and 66, penalties for unauthorized access and data thefts, section 66C and 66D, identity thefts and cyber frauds, section 69, government powers to intercept, monitor, and decrypt data. This Act is amended in 2008 to include data protection and cyber terrorism. CERT in Guidelines 2022. This legal framework is issued by the Indian Computer Emergency Response Team. It mandates reporting of cybersecurity incident within 6 hours, maintenance of logs for 180 days, syncing system clocks with NTP servers. It is applicable to service providers, intermediaries, data centers, and corporate bodies. RBI cybersecurity frameworks. This is applicable to banks, NBFCs, and payment systems. It requires board approved cybersecurity policies, real time threat monitoring, regular audits and cyber drills, reporting of incident to RBI. SEBI guidelines for stock exchange depositories and intermediaries. It emphasizes cyber risks assessment, crisis management plans, continuous monitoring and compliance certification. Data protection laws. These laws are proposed. Digital Personal Data Protection Act 2023 awaiting full implementation. It regulates collections, processing, storage and transfers of personal data, and it emphasizes user consents and data minimization. Now, Personal Data Protection Bill (PDBD) now evolved into the Digital Personal Data Protection Act 2023, that is DPDPA, is India's landmark legislation governing the collection, storage, processing, and transfer of personal data. It aligns India with global data protection norms like the GDPR. Now, what are RBI guidelines? The Reserve Bank of India (RBI) has issued several guidelines to strengthen the cybersecurity posture of banks and non-banking financial companies, that is NBFCs. These frameworks ensure resilience against cyber threats, protect customer data, and maintain trust in the financial system. SEBI Cybersecurity Framework. The Securities and Exchange Board of India (SEBI) has issued comprehensive cybersecurity and cyber resilience guideline for market infrastructure institutions such as stock exchanges, clearing corporations, depositories. These regulations aim to ensure business continuity, market integrity, and investors' protection in the face of growing cyber threats. Impacts on MIIs, stock exchange and depositories. Operational resilience. Its impact is improved capacity to prevent, detect, and respond to cyber threats. Compliance burden. High requires significant investment in tools, training, and audits. Transparency and trust boost investors' confidence and enhances market reputation. Data protection minimizes risk of data thefts or system manipulation. Regulatory scrutiny, regular SEBI inspections and compliance audits. Now, what are international standards? ISO IEC 27001. What is this? ISO IEC 27001 is the globally recognized standard for establishing, implementing, maintaining, and continually improving an information security management system (ISMS), published by the International Organization of Standardization (ISO) and International Electrotechnical Commission, that is IEC. Objective of ISO IEC 27001: it protects confidentiality, integrity, and availability, that is CIA, of information. Mitigate risk related to data breaches, cyber threats, and insider attacks. Establish a risk management based approach to information security. It ensures compliance with the regulatory and contractual obligations. Now, what is GDPR? The General Data Protection Regulation (GDPR) is the European Union's data protection law, effective since May 25, 2018. It regulates the collection, processing, storage, and transfer of personal data of individuals in the EU. Key objectives of GDPR are: protect individual privacy and personal data rights, give individuals greater control over their personal data, harmonize data protection laws across all EU member states, enforce strict obligations on organizations handling personal data. What is CERT-in? Indian Computer Emergency Response Team is the national agency for cybersecurity incident response, established under the Information Technology Act 2000 and functioning under the Ministry of Electronics and Information Technology, that is MIT. Role of CERT-in. Its functions are incident handling, alerts and advisories, threats intelligence sharing, vulnerability disclosure, security guideline, training and awareness, coordination with sectoral certs, and compliance oversight. That means it analyzes, tracks, and responds to cybersecurity incident in India. It publishes real-time security advisories and threat intelligence, collaborates with ISPs, service provider, and international certs, reports software hardware vulnerability and promotes coordinated disclosure, issues best practice for cyber hygiene and critical infrastructure security, conducts cybersecurity workshops, training programs, and awareness campaigns, works with financial sector certs, defense certs, and international bodies, and it enforces reporting norms under Section 70B of IT Act and Cert in Directions 2022. Cybercrime laws. Overview of punishment under Indian law. India's legal framework for dealing with cybercrime is primarily governed by Information Technology Act 2000, amended in 2008, and Indian Penal Code 1860, that is IPC, amended to include cyber-related offences. These are cybercrime laws: hacking, unauthorized access, cybercrime. Relevant section is IT Act Section 66, and the punishment for this act is imprisonment up to 3 years, fine up to 5 lakhs. Identity theft and phishing included in Section 66C. Imprisonment up to 3 years, fine up to 1 lakh is the punishment for this act. Cheating by impersonation, that is online fraud, it is included in Section 66D of IT Act, and the punishment related to this act is imprisonment up to 3 years, fine up to 1 lakh. Cyber stalking and online harassment is included in IPC Section 354D, and the punishment for this act is first offense up to 3 years, and the repeatedly offense up to 5 years plus fine. Publishing obscene content online, it is included in IT Act Section 67. First offense up to 3 years punishment, 5 lakhs fine, and repeatedly punishment up to 5 years and punishment of 10 lakh rupees. Child pornography, exploitative content included in IT Act Section 67B, and the punishment is up to 5 years imprisonment and 10 lakh fine. Data theft and data breach is included in IT Act Section 43 and 72. Penalties include damages by way of compensation up to 1 crore or more. Cyber terrorism included in Section 66F of IT Act, and its punishment is life imprisonment. Sending offensive message via communication services is included in IT Act Section 66A, struck down in 2015. This is no longer valid, declaration unconstitutional by the Supreme Court. Defamation online is included in IPC Section 499 and 500, and the punishment included is up to 2 years of imprisonment or fine or both. Financial cyber frauds, that is banking apps and UPI etc., is included in Section IPC plus IT Act Section 420, IPC 66D IT Act, up to 7 years of punishment plus fine. Now, data breach notification laws. These laws requires organizations to inform affected individuals and sometimes regulators when personal data has been compromised due to a cyber incident or unauthorized access. These laws country-wise are in United States, state laws, CCPA in California, and its notification for time is varies by state to state. European Union, law's name is GDPR, and notification time is within 72 hours. India, it is proposed in India also, Digital Personal Data Protection Act 2023, and notification time as soon as possible. In Australia, Privacy Amendment Notifiable Data Breaches Act 2017, and its notification time is as soon as possible. As soon as is practicable. In Canada, PIPEDA is the law name, and notification time as soon as feasible. Our learning outcome in this session are: we understand legal aspect of cybersecurity, and we understand regulatory bodies of and compliance in cybersecurity. In the next lecture, we will discuss more about legal and regulatory compliance in cybersecurity. Thank you.